I've chosen the subject of my presentation, the right of access to a lawyer under Irish and European law, for two reasons. Firstly, this is the annual lecture, as the Dean has pointed out, of the Centre for Criminal Justice and Human Rights. What better topic to choose than one which was the subject of the penultimate chamber judgment delivered in respect of Ireland in Strasbourg in 2019, the case of Doyle in Ireland, which I'll return to, a case which had previously occupied and divided the Supreme Court in 2017. And secondly, an overview of Strasbourg case law in relation to the right of access to a lawyer provides, in my view, a very suitable vehicle for exploring a broader topic, and one which some of you will know is close to my professional heart, namely the interaction between Irish and different strands of European law in a given field. So let's turn first to a brief overview of Strasbourg case law. The Strasbourg Court regards the right of everyone charged with a criminal offence to be defended effectively by a lawyer as one of the fundamental features of a fair trial under Article 6 of the Convention. And in 2008, in a landmark judgment, which I'm sure many of you are familiar with, Salduz against Turkey, the court held that access to legal counsel should, as a rule, be provided from the first interrogation of a suspect. In that Turkish case, which involved the interrogation of an unaccompanied minor accused of terrorist offences, and in subsequent cases, the court has emphasised the protective role lawyers play during pre-trial or the investigation stage of proceedings, and the close link between this procedural safeguard and the privilege against self-incrimination. In Salduz in 2008, the court also underlined the importance of the investigation stage for the preparation of criminal proceedings. Why? Because the evidence obtained during this stage determines the framework in which the offence charged will be considered at trial. Now, in some Turkish, French, Monegasque, amongst other cases which followed Salduz, there were suggestions that a restriction of a suspect's right of access automatically and irretrievably prejudiced the fairness of his or her subsequent trial, particularly when the basis for the restriction was mandatory or statutory in nature. However, it's now clear that the court's primary concern when it's examining a complaint under Article 6.1 of the Convention is to evaluate the overall fairness of the criminal proceedings. In other words, the court doesn't apply bright line rules in this field. Now, this overall fairness approach was made particularly clear in the 2016 judgment in Ibrahim and others against the United Kingdom. You will remember that tragically in 2005, 2 weeks after 52 people had been killed in the first London bombings, further bombs were detonated but failed to explode. At issue in the Ibrahim case were temporary restrictions on the right of access to their lawyers of some of the suspected bombers first questioned while the police were still searching for further bombs and perpetrators. In that case, the court made clear that the fact that the suspect's right to legal advice had been delayed in the investigation or pretrial phase did not automatically and irretrievably prejudice the fairness of their trial and conviction. And I'll come back to Ibrahim a little bit later. When it comes to the aims pursued by the right of access to a lawyer, the court has restated in the most recent Grand Chamber judgment, a case called Buzz against Belgium in 2018, that they include the following. The right seeks to achieve the following. First, prevention of miscarriage of justice, and above all, the fulfillment of the aims of Article 6, notably equality of arms between the investigating or prosecuting authorities and the accused. Secondly, providing a counterweight to the vulnerability of suspects in police custody. Thirdly, providing a fundamental safeguard against coercion and ill treatment of suspects by the police. And fourthly, ensuring respect for the right of an accused, as I mentioned earlier, not to incriminate him or herself and to remain silent. The Salduz case established the principle of early access, but what kind of access is required and what kind of legal assistance should be provided once access is granted. These details have been filled out in Strasbourg case law over the last decade. As a rule, A suspect should be granted access to legal assistance from the moment there is a criminal charge within the autonomous meaning of Article 6 of the Convention. A person acquires the status of suspect not when that status is formally assigned, but when the domestic authorities have plausible reasons for suspecting that person's involvement in a criminal offence, or when their position is substantially affected. And this point was made in the very high-profile case of Amanda Knox against Italy, with which some of you may be familiar. Now, in the Belgian case, Beuze against Belgium, the court distinguished two minimum requirements as being, first, the right of contact and consultation with a lawyer prior to the interview, and even where no interview has taken place, and secondly, physical presence of the lawyer during the initial police interview and any further questioning during the pre-trial proceedings. Now, the following paragraph from Dayanan against Turkey, a case decided in 2009, demonstrate that the Strasbourg court has, for many years, been reasoning in terms of the provision of effective legal assistance, viewed broadly, and not merely in terms of a narrower notion of technical legal advice. In Dayanan, the court held, counsel must be able to secure, without restriction, the fundamental aspects of that person's defence, and I quote, discussion of the case, organisation of the defence, collection of evidence favourable to the accused, preparation for questioning, support for an accused in distress, and checking the conditions of detention. Furthermore, the court has stressed that a merely passive presence of the lawyer, without any possibility at all to intervene to ensure respect for the suspect's right, doesn't meet convention standards. The Saldo's principle that, as a rule, access should be at a very early stage means, as I said before, that it's possible for access to legal advice to be exceptionally delayed or restricted. Indeed, it's important to recognise a certain shift from the early Turkish cases to the more recent Grand Chamber judgments in Ibrahim against the United Kingdom and Beuze against Belgium. What did the court clarify in these cases? It made clear essentially that the applicable test consists of two stages. First, you have to look at whether or not there are compelling reasons to justify any restriction on the right of access to a lawyer, and then you have to examine the impact of any restriction on the overall fairness of proceedings. Now, restrictions on access are permitted only in exceptional circumstances. They must be of a temporary nature, and they must be based on an individual assessment of the particular circumstances of the case and the situation of the suspect. When assessing whether compelling reasons have been demonstrated, it's relevant whether the decision to restrict legal advice has a clear basis in domestic law, a point in relation to Ireland I'll come back to a little bit later on. Now, such compelling reasons will exist, for instance, when it has been convincingly demonstrated that there was an urgent need to avert serious adverse consequences for life, liberty, or physical integrity in a given case. In such circumstances, there may be a pressing duty on the authorities to protect the rights to life and liberty of others. And the UK case of the London bombers provides a very graphic example of this. Where the right of access has been restricted, the onus will be on the authorities to demonstrate the existence of compelling reasons. Where there are none, very strict scrutiny will apply. And the absence of compelling reasons will weigh heavily in the balance. A non-exhaustive list of factors drawn from convention case law has been developed, which the court will take into account where appropriate when examining the proceedings as a whole in order to assess the impact of procedural failings at the pre-trial stage on the overall fairness of the proceedings. For example, did the accused have the opportunity to challenge the authenticity of the evidence and oppose its use? What was the quality of the evidence available? And did the circumstances in which it was obtained cast doubt on its reliability or its accuracy? And did the evidence obtained as a result of the restriction of the accused rights form an integral or significant part of the evidence upon which the conviction was based? Now, turning from the Convention and Strasbourg Case Law to Irish law, how has the right of access to a lawyer been guaranteed over the years in this jurisdiction, in Ireland? Some members of the audience will no doubt be very, very familiar with this case law. Some will be less familiar, but allow me to recap for all, because the progression of Irish case law in this field feeds directly into the broader question of how Irish and European law interact. Initially, Irish courts didn't recognise a constitutional right to consult with a lawyer while in custody. In 1978, for example, the existence of such an entitlement was rejected by the Court of Criminal Appeal in the case of DPP against Farrell. The right was, of course, eventually recognised as a constitutional entitlement in the landmark 1990 decision in DPP against Healy, where Chief Justice Finlay stated, and I quote, "The availability of advice from a lawyer must be seen as a contribution towards some measure of equality in the position of the detained person and his interrogators." But Healy simply provided that the constitutional right to access legal advice was one of reasonable access to a solicitor while in custody. In 2002, in DPP against Buck, the Supreme Court defined what reasonable access meant, namely, bona fide efforts on the part of the police to contact a lawyer and facilitate legal consultation. This meant that provided good faith efforts were made by police to secure access to legal advice, failure to facilitate consultation between a detainee and his lawyer prior to questioning would not automatically lead to exclusion of subsequent incriminating statements as unconstitutionally obtained. In 2013, in a case called JM against MIC Coolock Garda Station, the High Court confirmed that there was no requirement to have a solicitor present, despite the detainee in that case being a vulnerable minor with mental health difficulties. But let's fast forward to 2014, and we see that the Irish position was altered significantly by the Supreme Court in a case many of you will know, DPP, Gormley against White. Now, in that case, the Supreme Court, in a judgment scripted by Mr. Justice Clarke, as he then was, held that the need for basic fairness recognised in the 1990 Healy case and inherent in the trial in due course of law guaranteed by Article 38(1) of the Constitution carried with it an entitlement not to be interrogated after a request for a lawyer had been made and before that lawyer had become available to tender the requested advice. Mr. Justice Clarke considered that the conviction of a person wholly or significantly on the basis of evidence obtained contrary to those constitutional entitlements represents a conviction following an unfair trial process. The Supreme Court's constitutional shift was marked, in the words of one commentator, and I quote, by considerable reliance on the case law of the Strasbourg Court. And indeed, importantly, Mr. Justice Clarke suggested that in the light of extensive Strasbourg case law, the Supreme Court's decision was not one which, in his words, and I quote, could reasonably be said to have taken the domestic authorities by surprise. The Supreme Court position was also borne out by the fact that a working group established in 2013 to examine this question had received clear legal advice to the effect that the Irish law fell short of the Saldus principles. Now, in the wake of Gormley, the state introduced a code of practice on access to a solicitor by persons in Garda custody. This code permits the presence of a solicitor during interview if necessary. The code of practice was promulgated following a direction issued by the DPP. And the Law Society of Ireland has also developed guidance for solicitors providing legal services in Garda stations. And as far as I understand, a supralat project funded by the European Union was set up to provide training in this regard. It seems clear, however, that these directions, codes of practice and guidelines are not legally binding in the same manner as a statutory framework enacted by the Oireachtas would be. And the existence of a clear legal basis is relevant. We see this in the Ibrahim case that I just mentioned, and we've seen this in a different Irish context in relation to the absence of a formal procedure in domestic law regulating undercover police operations in the case of Mills against Ireland. Now, as far as I understand, a legal provision to govern questioning also in urgent situations along the lines of the Ibrahim London bombers case formed part of the 2011 Criminal Justice Act but this provision hasn't yet commenced. And I also understand that the government gave assurances in 2014 to the Committee on the Prevention of Torture that there was a possibility that an instrument, a statutory instrument, would be adopted in this field. Now, while the constitutional right of access to a lawyer has clearly included, since 2014, a right to legal consultation prior to questioning, Irish courts had never recognised in a case where this was at issue that the right encompassed entitlement to have a lawyer present during the questioning itself. In 1982, in the case of DPP against Pringle, the Supreme Court had rejected the existence of such an entitlement, and post-Healy in 1999, the Supreme Court in Lavery confirmed this position. It's important to stress that in the Gormley case in 2014, the question whether a suspect is entitled to have a lawyer present during questioning did not arise on the facts of that case. However, in an obiter, Mr. Justice Clark considered, and I quote, "The jurisprudence of both the European Court of Human Rights and the United States Supreme Court clearly recognises that the entitlements of a suspect extend to having the relevant lawyer present." The question of this entitlement was front and centre in the 2017 case of DPP against Doyle. Now, some or all of you will know of this tragic case. It arose from the fatal shooting of a young man in Limerick following a case of mistaken identity. The suspect had had access to a solicitor before being interviewed and between interviews, but was not allowed, given the position in Irish law at the time, to have his solicitor present during the interviews themselves. Some of those interviews, and I should perhaps add to the surprise of my colleagues in Strasbourg, were interrupted in order to allow both the solicitor and the suspect to exchange by telephone. The suspect made, in the course of one of several interviews, statements incriminating himself in the shooting with which he was then charged. A divided Supreme Court, whose judges issued 6 separate judgments, confirmed that there is a fundamental requirement of basic fairness which applies from the time of arrest and throughout the trial process. However, the majority rejected the submission that securing basic fairness during the pre-trial stage required the presence of a lawyer during questioning. Mr. Justice Charlton, writing for the majority, offered several reasons for this conclusion. First, he said there was no decision of the European Court of Human Rights stating that there must be a solicitor in the room. Second, the requirements of basic fairness could be protected via other procedural safeguards applicable from the moment of arrest, which, and I quote, had been closely and carefully constructed over decades of experience and were characterised by transparency and judicial scrutiny. Concurring, Mr. Justice O'Donnell found that it cannot be said that it has been definitively determined that the Convention requires a bright line rule that in a common law system, an accused person must have not just access to, but the assurance of the presence of a lawyer during any detention. He didn't exclude further developments of Irish law, but his position was influenced by different factors, not least a narrower view of the role of a solicitor than that which had been emerging from the Strasbourg Case Law, and a distinction between cases pre- and post-Gormley. He found it significant that, and I quote, "the jurisprudence of the European Court of Human Rights has to date largely been developed in the context of civil law systems with early supervision of investigation by a magistrate, and not in common law systems like Ireland." It's worth noting that this theme, to which I'll return, namely the origins and natural sympathy of convention case law for civil law systems and the difficulties to which this may give rise for common law ones, is one which has recurred in recent years in some Supreme Court judgments. Mrs. Justice O'Malley concurred with the result of the majority, but she found, referring to the Gormley case and indeed its reliance on the Saldus Strasbourg judgment, that this could logically lead to a ruling that the right to a fair trial implies a constitutional right to the presence of a solicitor during questioning. Mr. Justice McKechnie, in dissent, took a different view. He acknowledged that judicial overview is an important tool for preventing abuse. but he said that this in itself wasn't sufficient for securing basic fairness in pre-trial custody. Central to his position was the need to ensure a degree of equality of arms, the same equality, if you remember, which had been emphasised by the Chief Justice in Healy in 1990. Crucially for the purpose of today's discussion, Mr. Justice McKechnie also based his conclusion on the case law of the Strasbourg Court, which he considered had great persuasive balance, and which he identified as already recognising the right to have a lawyer present during questioning. He emphasised that an international legal trend was not in itself a decisive reason to establish the existence of the right in Irish law, but he found a broad trend of recognising such a legal entitlement could not be overlooked. And in bolstering his conclusion, he referred not only to Strasbourg case law, but also to the existence of the right in the United States, England and Wales, Scotland, and other EU member states by virtue of a new EU directive. Concluding this Irish section, it's important to note that there's an important distinction between permitting a lawyer to attend an interview and recognising that a suspect has a constitutional or conventional right to the lawyer's attendance. Now, when the case of Doyle against Ireland came before the fifth section of the Strasbourg Court in 2019, this court found by 6 votes to 1 that the applicant's fair trial rights under Article 6 of the Convention had not been violated. The Strasbourg Court found that there had clearly been a restriction of his right of access to a lawyer as defined by this court. However, it concluded that the overall fairness of his trial had not been irretrievably prejudiced as a result of this restriction. Now, the reasons for this were several. The suspect had been provided with legal assistance from the outset. He hadn't been particularly vulnerable. Crucially, the admissibility of evidence was tested during a 10-day special procedure, and the jury was given detailed instructions regarding how to approach the suspect's confession and also the evidence. Allegations of the use of psychological intimidation had been extensively considered by the Irish courts. The applicant's conviction had been based on a voluntary confession of his guilt, but this had been supported by significant independent evidence, and there had been other important procedural safeguards, such as the fact that all the police interviews were video recorded and reviewed by the judge. The lawyer had been able to interrupt the questioning, and the lawyer had played a central role between the suspect and communication between the suspect and police. The Strasbourg Court did, however, point out that the Supreme Court had either misconstrued or missed an important point of convention law. At paragraph 101 of the judgment, it stated, and I quote, "While a majority of the Supreme Court, which engaged extensively with the court's case law on Article 6, was correct in concluding that where there have been procedural defects at pre-trial stage, the primary concern of the domestic court at trial stage and on appeal must be the overall fairness of criminal proceedings. The court here added, the Supreme Court failed to recognise that the right of an accused to have access to a lawyer extended to having that lawyer physically present during police interviews." The reference in the Supreme Court judgment in the Doyle case to an EU directive brings me to the third element of the equation, EU law, which I think one must address before looking at the broader theme for discussion, namely the interaction between Irish and European law in this field and beyond. Like me, many of you are still probably surprised to see what impact EU law now has on member state criminal law. Since the Lisbon Treaty, Article 82, paragraph 2 of the Treaty on the Functioning of the European Union provides a clear legal basis for the establishment of minimum rules applicable in member states so as to facilitate the mutual recognition of judgments and judicial decisions and police and judicial cooperation in criminal matters. This was a very large extension of EU competence at the time of the Lisbon Treaty. And in 2013, the EU adopted Directive 213/48. The objective of the directive, recalled in recital 12 of the preamble, is to set common minimum rules for the right of access to a lawyer in criminal proceedings and those for the execution of a European arrest warrant. And the 2013 directive is one of several EU instruments which now seek to protect suspects' procedural and defence rights. It had to be transposed by 2016, and it applies to all EU member states except for Denmark, Ireland, and previously the United Kingdom. And if you want to trace the DNA or the origins of EU directives like this, it's essential to unpick the recitals. And as noted by the Strasbourg court, this court, in its judgment in Ibrahim and others against the United Kingdom, the origins of the 2013 EU directive clearly lie in Article 6, paragraph 1 and 3c of the Convention. Yet an EU directive does what a general provision of an international convention adopted in 1950, and which seeks merely to establish minimum standards in 47 very different states, cannot do. An EU directive sets out in detail the component elements of the right at issue, and it does so in a legislative text which enjoys probably both direct effect and certainly supremacy, and with the overt intention to harmonise the law in the member state to which it applies. Article 3 of the directive concerns the right of access to a lawyer in criminal proceedings. It corresponds to a codification, more or less, of the Strasbourg Case Law that I've just outlined. The EU right of access entails the right to consult prior to questioning, during questioning, and the attendance of the lawyer during certain investigative and evidence-gathering acts, such as identity parades, reconstructions, and confrontations. Few cases on the interpretation of the directive have thus far been decided by the Court of Justice in Luxembourg, but no doubt one can expect that this to change over time, unless national courts feel that they aren't in any need of interpretative guidance from the EU court, used as they are dealing with Article 6 of the Convention for many years. But on this point, we'll have to wait and see. I'll make one important point, which I think is of significance for Ireland in relation to the directive. The fact that it codifies existing Strasbourg case law, perhaps indeed going beyond it, doesn't prevent the Luxembourg-Strasbourg traffic becoming two-way in a field like this. In the UK case, Ibrahim against others, in the absence, for example, of a clear definition in this court's case law of what constitutes compelling reasons which could justify restriction of the right of access, the Strasbourg court dipped into Article 3, paragraph 6 of the directive and made the definition there its own. And it could be argued that such cross-fertilization means that even member states like Ireland, which opted out of the EU directive, will not necessarily be immune to its effects. This brings me to the question of parallel lines and/or convergence. From the brief overview of the three interrelated systems I've just provided, we see clearly that Irish authorities and courts are faced with a right whose legal basis and more or less detailed parameters can now be found directly or indirectly in three different sources: the Constitution, the Convention, and an EU law directive, which in turn is partly based on the EU Charter. In this concluding part, I want to tease out some of the consequences of a right having three sources and probe how Irish courts may be engaging with the two European ones. I'll limit myself to 3 points. The first point relates to the diversity of criminal justice systems and the particularities of the common law. For the Strasbourg court, it's important to stress that what constitutes a fair trial is not and cannot be subject to one unvarying rule. It must depend on the circumstances of the particular case. And indeed, in the Doyle case, this court clearly stated, and I quote, "Its role is not to adjudicate in the abstract or to harmonise the various legal systems, but the role of this court is to establish safeguards to ensure that the proceedings followed in each case comply with the requirements of a fair trial." And the reason for this tendency not to harmonise, but rather to provide minimum standards which can apply across 47 states is quite simple. The convention system must cater for very different inquisitorial and adversarial systems. In the former, in inquisitorial systems, there was a long tradition of custodial interrogation by the prosecutor or investigating judge, which often excluded the defence. and this explains why many of the early judgments post-Saldus were in relation to states like France, Monaco, or indeed Luxembourg. While the case law I have outlined developed in cases originating in those and other civil law systems, it was quickly applied in 2010 by the neighbouring common law jurisdiction, the UK, in the case of Cadder against Her Majesty's Advocate. So the question I ask is the Strasbourg approach to the right of access to a lawyer geared towards continental systems, or does it bear excessively the imprimatur of the civil law? In the Supreme Court judgments in Doyle and in other cases such as Nash against the DPP in relation to unreasonable prosecutorial delay in criminal cases, one sees a recurring theme along these lines. In Nash, it was expressed in the following terms by the Chief Justice, and I quote, "There may be some doubt as to precisely how the established jurisprudence of the European Court of Human Rights can fit into an assessment of when the criminal process can be said to have begun in a common law system. In such a system, there is no formal investigation in the sense either of the matter being formally under investigation through a public prosecutor or an investigating magistrate or other judicial or quasi-judicial figure. In the common law system, as we know," he said, "there's simply evidence gathering, a consideration of evidence so gathered by the DPP, and a decision on whether the evidence so gathered is sufficient to warrant a charge." 2 points are worth making in my view. First, the two-stage approach consolidated by the Strasbourg Court in Ibrahim and others against the United Kingdom and in subsequent cases, with its emphasis on overall fairness and the possibility of procedural safeguards applied by a trial judge, remedying unlawful restrictions on the right of access which occurred at pre-trial stage, could be and is often regarded by civil lawyers as very common law friendly. Compare, for example, the 10-day meticulous voir dire in the Doyle case and the absence of the same type of special procedure in the Belgian case Buzz. What was the result of that difference? In the Irish case, the court found no violation by 6 votes to 1. In the Belgian case, it found a violation of Article 6 by 17 votes to 0. The second point is that in Gormley, Mr. Justice Clark pointed out quite rightly that the line between investigation and trial is not necessarily the same in each jurisdiction. But does this not also risk missing the heart of the Saldus case? The heart of that case is, regardless of where the line between investigation and trial is drawn, a suspect has a right of access to a lawyer on both sides of that line. From the moment he or she becomes a suspect, or to use the court's words, from the point at which his situation has been substantially affected by actions taken by the authorities. The Strasbourg Court has and must, when establishing minimum procedural and defence rights, communicate with both civil and common law systems, and with procedural traditions in the different member states which adhere to those different systems. The acceptance of Saldus, however, since 2008, across the board, and in some common law jurisdictions like the UK, many years before our own, suggests that it has done this relatively successfully. What the Strasbourg Court needs, of course, is that domestic courts explain the difficulties which a given line of case law may cause, given the particularities of the domestic legal system. But we as a state, a people, and I think a legal community, have generally been very sceptical of exceptionalism, and I hope we'll continue with this healthy skepticism, even as we assert and explain our beloved common law. The second point I would make is that this Irish case law in this field maps quite well the Supreme Court's engagement with the Convention and with Strasbourg case law. The European Convention on Human Rights Act of 2003 indirectly incorporates the Convention into Irish law at sub-constitutional level. However, regardless of the manner chosen to incorporate it, the Convention is first and foremost an international treaty to which the state is a party. In the words of Clark in Gormley, the executive long since committed Ireland to compliance with the Convention as it is interpreted by the European Court of Human Rights. And in Gormley, we saw the Supreme Court reiterate the consequences of this commitment and delve into established convention case law in order to develop or identify the existence of a corresponding right of access to legal advice, which it then firmly grounded in the Constitution. However, what's also interesting in that support for this development, Strasbourg case law didn't appear to be sufficient for the Supreme Court. Additional support was sought in Gormley from Supreme Courts of other common law countries with similar procedural traditions, eschewing references to other Council of Europe states and to EU law. And one commentator has described this as an excellent example of legal cosmopolitanism, but nevertheless cosmopolitanism from the angle of the common law. It's worth asking whether a similar degree of cosmopolitanism has been demonstrated in other Supreme Court decisions, both on the issue of the right of access to legal advice and in relation to other cases. In Doyle, as we saw, only 3 of the 7 judges were willing to recognize the clear direction of travel, if not the already reached destination of Strasbourg case law on the right of access to a lawyer. And this was despite the clear recognition of the relevant right by Clark in Gormley 3 years previously, albeit in an obiter. In Simpson, a case on slopping out in Mountjoy Prison, it was stated, and I quote, "The function of the Irish courts is to uphold the Constitution, and that duty cannot be performed if the scope of rights protected under the Constitution is to be protected and determined by the jurisprudence of a court, the Strasbourg Court, which is not established under the Constitution and has no obligation to uphold it." In O'Callaghan, a case about unreasonable delay, the Court of Appeal was more accommodating, referring to the persuasive value of convention case law and describing the constitutional claim for damages and one under the convention in cases of unreasonable prosecutorial, judicial or systemic delay as being siblings rather than identical twins. The differences between the convention and the Constitution are clearly highly significant, and they are differences which counsel would do well to keep in mind when appearing before the Supreme Court. In the words of O'Donnell in Gorey against Minister for Justice and Equality, a judgment handed down earlier this year, there's no need to treat the constitutional and convention provisions as interchangeable. Indeed, there are good reasons relating to the language of the documents, their distinct histories, and the functions they perform to approach the questions separately and distinctly. The Strasbourg Court has for decades consistently recognized the centrality of the Constitution and domestic judicial decision-making in a common law constitutional system such as ours. However, 70 years, almost to the day, since the signing of the European Convention of Human Rights, it seems possible to assert and reassert the predominant, central, and indeed vital position of the Constitution in the Irish legal landscape, while recognizing that the Convention and Strasbourg jurisprudence can prompt changes, dare I say, even some healthy changes in Irish judges' general understanding of human rights, which may in turn lead to changes in constitutional doctrine. This is, after all, as Eamon Gilmore emphasised last week in an article in the Irish Times to mark the 70th anniversary of the Convention, an international treaty and a court which have wrought us Lawless, Airy, Norris, Open Door, Independent Newspapers 1 and 2, A, B and C, O'Keefe, Keady and McGuinness, and of course Doyle, to name but a few. The third, final, and much shorter point I will make relates to the interaction between the Convention and EU law and the effects in Ireland in this regard. Ireland opted out of the 2013 Directive based on what the competent minister indicated in the Dáil in 2019 were substantive legal concerns. He said, and I quote, "Chief amongst these concerns were that the original proposals would affect Irish criminal law procedures fundamentally and make serious changes to the law on the admissibility of evidence. I understand that the opt-out or the opt-in is under review. Yet if an EU directive codifies Strasbourg case law, and Strasbourg in turn interacts with the EU directive and how it's being interpreted by the Court of Justice in Luxembourg, do the effects of the directive not in any event permeate Irish law, albeit indirectly?" Time is running out, so I leave that question hanging in the air and I'll leave the answer for your lecturers and scholars. To the students present, I would simply say in conclusion that when learning the law, it's a grave mistake, in my view, to consider yourself solely Irish lawyers. By necessity, you must look outwards, like your law faculty has always done, and become Irish and European lawyers. And I hope this evening I've illustrated why this is both necessary and very worthwhile. My warm thanks to all of you in Cork and to everybody else connected from wherever you are. I hand the floor back to you, Fiona.
Many thanks, Judge O'Leary. That was a really excellent and almost spot on time. Very impressed by the timekeeping despite the distance. And it's so nice to be able to welcome you to Cork virtually and to hear such an excellent presentation for the annual lecture. We really have been privileged, I think, this evening to hear your thoughts on this. I'm aware there's 10 minutes left, and we are going to keep a tight timetable. But I do want to just say a couple of things in reflection of what you've said, because I think your presentation this evening has really been incredibly important. Thinking about the 70th anniversary that we've just had of the signing of the convention, and I think your concluding comments about how important it is for us to be looking out to Europe and for our students to be looking out to Europe. And it certainly is, as you've noted, something that we in the law school are very conscious of and very much engaged with in terms of the interconnectedness, I think, of Irish law through into Europe. And then that's the other really powerful thing you've given us. It's not just an insight into the particulars of right of access to a lawyer in this talk, but it's also that those parallel lines that run between ECHR law, EU law, and our constitutional law, which all too often we tend to take for granted or forget about. But I think an example like this really shows the power and those interconnections that are so important and will continue to be so important, I think, in our lives.